juntos podemos seguir avanzando hacia un entorno empoderado, igualitario y seguro para todas ustedes. Muchas gracias, nuevamente bienvenidas y repito, esta es su casa. 감사합니다.
Thank you. Hello. My name is Hwang. I'm from Seoul Law Group. I'm a principal lawyer of Seoul Law Group. Thanks for having me here to discuss this important topic with you today. Hope I can speak Spanish like you, but English is my best second language, so I will try to proceed as kind of easy and slow as possible with my English. Okay, so yeah, today we will talk about we will learn about important topics about divorce in Korea. This is I will explain myself to you first, but she already did very in detail, so simply. And number two, there's 3 different types of divorce in Korea, so we will talk about it. And number 3, there's 4 important criteria we need to think about in divorce proceedings. We will explain about that. And recently, the law about jurisdiction was changed like 2 years ago. So some cases we cannot handle in Korea anymore. So we need to think about it. If could be yours, could be your friend's case can be handled in Korea or should be handled in another country. Number 5, after divorce, we also need to think about visa option because I'm a lawyer for foreigners in Korea, so most of our client, more than 95% of client is foreigner. So every case we handle, we need to think about the visa after this case. So we will talk about it also. And last part is Q&A session. Yeah, fancy picture is me. I'm founder and managing partner of Seoul Law Group. I have 8 years experience assisting foreigners in Korea with legal matter. Okay, this is 3 different types of divorce. First one, mutual consent divorce. We also call it as settlement divorce. This is available when both parties agree and file the required document with the family court in person together. I told you there's 4 different category criteria we need to think about. All 4 criteria when both spouses can make a settlement, means agreement, they can just go to the court and get the divorce certificate, not decree. All of these different types of divorce, there's pros and cons. Best strength of the mutual consent divorce is timely and costly efficient. So if you're not comfortable with it, I will say your friend, but just let's go with you. So if you and your husband kind of discussed and agree that okay, let's divorce and let's make the custody, who will have the custody, how to divide the asset. When you make all the agreement, then you go to the court together and file we want it. Then 1 month later, if you have no child, 3 months later, if you have a child, you need to go to the court together again and get the final certificate from the court. So it's very fast and you don't need to hire a lawyer. Literally, you cannot hire a lawyer for that. Lawyer cannot go to the court together with you. So you should handle everything by yourself. You can get advice out of the court, but you cannot get help in the court. So it is very fast, it's cost efficient, but the first issue, weak point is you cannot get a verdict. They will just give you certificate, 1-page document, which was written by yourself, and they just stamp it. If you're okay with it, you can just bring the document to the GU office, community center, and register it. Then, when you issue your family relationship registration in Korea, you can see that your status was married to divorced. So it's okay, but if you need to get decision about your child, then you need to write down all the detail by yourself with your spouse in the court in Korean. So it's quite hard. So division of asset, you need to sometimes give some money to your spouse, sometimes get money from your spouse. Then you need to go to the notary office and make a separate agreement about division of asset. Korean court will not handle about your asset. So it's easy, but I advise to choose this option when you only want divorce. If you have a child, if you have an asset, better to go to the different option. And the second point of this divorce by settlement is you cannot get a verdict, only the certified document. That means if you want to register your divorce in your country or another country, that could be an issue. Some countries accept that certificate as a finalized document, but some countries require verdict from the court with the judge's statement. So if you have that desire, need, then better to go to the next option. So the next option, mediation divorce, is court-mediated resolution for disagreement. That's the kind of official definition of the mediation divorce. So the last one, let me explain the last one first. Litigation divorce is exactly a different route with the settlement divorce, mutual consent divorce. It takes a long time, at least more than 6 months. Sometimes it goes to 2 years if you or your spouse appeal it, and it could take 3 years. So it's timely, costly, not efficient. But sometimes there's no option with number 1, number 2, when you and your spouse cannot make a settlement in detail. For example, there's a child and both spouses want to have the custody, cannot make settlement. Then the only option is get judgment from the court. So that is the litigation divorce. But to go to the litigation divorce, it requires proof of fault. That means if you agree, you and your spouse agree with the divorce, but cannot make settlement with the child custody only, or child and asset, you also can choose litigation divorce and say to the judge, we already agree with the divorce. You don't need to judge about that, but we want a judgment about child and asset. But sometimes you want divorce, but your spouse doesn't. Or sometimes you can get a kind of document from the court saying that your husband or your spouse want divorce, but you don't. Then the plaintiff, means who want a divorce, need to prove the fault of other spouse. For example, adultery, domestic violence, abandonment. Abandonment means like leave you at home and just disappear. Could be a year, 3 years, 5 years, like that. So that is the litigation divorce. We can discuss in detail about detail next part. But let me explain about the difference of these 3 options. So then, what is mediation divorce? Litigation divorce, again, it takes too long time to spend. So we can initiate with the divorce, mediation divorce, saying that I know we couldn't make a settlement yet, but we don't want to fight in front of the judge with like everything to be revealed. We need a mediator, judge, and we can discuss together one day, and I think we can get a conclusion. Then we can initiate the divorce, mediation divorce. That is the formal definition of mediation divorce. Then you will go to the court and discuss together and make a settlement with the judge. That's all. But often used for the sweep judgment. That means, imagine that it's 2 different stories. First one is very famous, like stars, entertainer in Korea. They get divorced, right? They don't go to the litigation divorce normally. They just hire a lawyer, and the lawyer make a settlement on behalf of them without court, out of the court, and make a final document. We call it separation agreement. and filing to the court saying that we already have a settlement, but the stars will not go to the court by themselves. Also, we don't need litigation because we make a settlement. We have each lawyer in each party, so just make a decision based on our separation agreement, which was already made. So, as a lawyer in Korea for foreigners who sometimes not in Korea, they can take us and ask, I want to divorce in Korea, but I don't want to go back to Korea. Is it possible to handle the case without me entering Korea? Also sometimes without my spouse entering into Korea. Then we can arrange that kind of already agreed divorce with mediation divorce process. So I will be one of my client's lawyer, and I also have another lawyer out of my law firm, so there's no conflict. We arrange the lawyer for the spouse of my client. So my client and the spouse who is not in Korea get divorce decree without entering Korea with one court hearing. It takes normally 2 months and 1 or 2 weeks from the day we file the case. So if there is a trial, it is faster than settlement divorce, right? So this is the options, and when you or anyone need to get divorce decree in Korea, we can explain about this with the consultation again. No, what happened? Okay, so this is key considerations in divorce 4. Divorce petition. That means if you can get divorced or not, if the other party doesn't agree. If agreed, why not? Yeah, we can just pass and move to the child custody. But if other party, spouse, doesn't agree with the divorce, we need to prove that there is a fault. As I explained, there are 3: domestic violence. Sometimes it's addiction, like alcohol addicted, or drug, or abandonment. That is the number 1 and kind of 0 of this whole process. If there's no, we cannot prove that, we cannot get the divorce decree at all. What does it mean? Like child custody and division of assets, nothing. So when we pass that, number 1, and number 2 is about the child, if you have any. 3 different categories in there. The first one is who will have the custody. Number 2, how much the non-custodian need to pay as a child support. Number 3, how the non-custodian can see and visit the child. So making agreement or making judgment, getting judgment, we need to think about these details with lawyer. So normally, if I explain simply, child custody, 2 most important factors. First one, who is mother? Second one, who is raising the kids now? So if you're a mother and if you take care of baby now, then I just normally explain that more than 90% you will get a custody if you want to. That is Korean court kind of start out of the judgment. So otherwise, I also have a male client. When they ask me if I can get a custody, my answer is 2 factors. So at least you need to kind of to care of the baby so far, but maybe not. Yes, it is not true. Then it's better to just give up and try to get as much vegetation time as possible. And sometimes we need to think about reduce the amount of the child support. But as a woman's mother's party, as a custodian, we need to maximize the child support every month. And also, vegetation right, I think is so the court decision of the vegetation right is always focused on the welfare of the child. All of them, child custody, child support, vegetation, focused on child's welfare. So even if the guy or the one party is really bad, court doesn't care about that with the visitation right. Even if he's bad father, bad mother, child has a right to see the father or the mother. So there is a kind of standard and kind of form about child's visitation. So if you have another different situation, we can amend it differently. But normally, Korean court already had that system of the visitation right. It's like by week, like 1 week with mother, 1 week with father, and vacation. Non-custodian can take like 7 to 8 days in summer vacation and winter vacation, like that, like Thanksgiving, Chuseok in Korea, special visitation, like that. Child support. There is also a table in the Seoul Family Court. It is combination with the spouse income and the age of the child. So more income and more older kids, they get more child support. Less income and younger child get less child support. So there is a table, so you can check it. Yeah, that is the custody part. And the next one is property division. Two things you need to think about. First one is which asset will be on the table to be divided. For example, the house you already have before the marriage will not be included to the division of asset, right? It should not be divided. It's yours, already yours. So after the divorce, it should be yours, not to be divided. So some asset should be included on the table to be divided, but some asset is deducted, not included on that. So that part, normally people need lawyer. Child custody, you can write your letter to the judge why you need custody and why you need this amount of child support. There is a table, you can check it. But property division is kind of professional area. So if you meet better lawyer, you can get more asset. Otherwise, it could be less. So first one is about determining which asset should be divided, and second part is the ratio, how much percentage you will get from that whole amount of asset. Normally, the first stage of determining the ratio is based on the income, who earned that money for the marriage period. So if the husband earned like 70% and wife's salary in total is 30%, it's 7 to 30. But if the wife raised the child, normally more than 5 years to 10 years, less than 5 years will not be considered that much. But if it is more than 5 years, very heavily considered that taking care of baby is kind of earning money. So it will be strongly considered. And if the marriage period is more than 10 years, normally we can claim 50-50 and it is accepted. Even if husband earned 90% of the asset, but wife took care of child for more than 10 years and maintained the marriage, then wife have right to get 50% of the asset. That is a kind of rough explanation about the ratio. You can use it when your friend asks. And the last part is compensation. In Korea, we call it 위자료. 위자료 sometimes translated to alimony, but there's no concept of alimony in Korea. I'm not familiar with the US law, but I know what is alimony in US. It's kind of combination with the support for child, but more than that is support for the wife. But in Korea, law doesn't care about wife's welfare after the divorce. Instead, so there's no concept of alimony in Korea, but instead there's compensation, which means damage compensation, which means if your spouse had a fault, that's the reason of this divorce, then you can charge compensation against him and get lump sum with this court decision. So could be other spouse support after the divorce. So to do that, we need to also prove the at fault of the party with adultery and other thing. Normally, if I speak more in detail, if you have a child and the spouse make adultery, it begins with 20 million Korean won to 30 million Korean won. And our trend now is the amount is getting bigger. So making adultery need to pay the compensation. This is a bit complicated issue, jurisdiction. So in Korea, the law, private international law, which was amended 2 years ago, say that before this law actually, I handled almost every divorce case for foreigners in Korea. There was no limitation. But sometimes I also felt that this case really should be handled in Korea. I think this case should be handled in US or in Mexico or in Japan because I think the case is more close to their country, not Korea. They just want to use Korean court. I was thinking about that, but it was good because I'm the lawyer, so I handled it. It was good for me, but they finally changed it and I was so disappointed. Let's see. So it is condition of the case which can be handled in Korea. Let's see the number 3 first. Okay, both spouses are Korean citizens. Why not? Yeah, there's no, definitely they should be handled in Korea, right? But number 1, one spouse lived in Korea and the couple's last home together was also in Korea. So recently I had 2 cases which I rejected. Was one spouse is Korean and one spouse is foreigner. They are, okay, I can say they are in UK. And husband said, my wife will go to Korea and she will handle the divorce case in Korea. So please help. Please be my lawyer. I'm UK citizen. So I said, okay, but it was possible, but now it is not possible because one spouse lives in Korea, right? His husband, wife will come, but the couple's last home together was UK. So they cannot get divorced in Korean court system. Think about that. I think it makes sense, right? They are in UK, and why not? They should handle it in UK. That's why this law made. Number 2. Person filing the case and some or all the minor children lives in Korea. The person filing the case is plaintiff, right? There's plaintiff who initiate the case and there's defendant who defend the claim in the civil case. So the plaintiff, the person who filed the case, should be here in Korea, live in Korea. And if there is a child, at least one of them should be here in Korea together. Or they will not handle it. The Korean court will not handle it. So there's 4 different conditions which the divorce can be handled in Korean court. Number 4, the person filing the case, the plaintiff, is a Korean citizen living in Korea. Number 2, simultaneously, and is filing the case only to end the marriage. That means, let's go back to the case for example, the UK case. If they don't have a child, if they only want to get divorced, then they can make divorce decision here in Korea with number 4, because one of the spouse, the wife, is Korean citizen and came back to Korea, so living in Korea and only to end the marriage. That means she will not or he will not claim any custody issue, any division of asset, any compensation. Only want to get divorce decree, then okay, we will handle it. Even if they are not in Korea, one of them is not in Korea. So this law made in 2022. So now everything's getting harder to handle in Korea. But still, if you have any kind of issue with divorce, just ask. Let me know. I will answer if it's possible or not. Okay. Now the visa lawyer came, so we need to talk about the visa now. Okay, so after the divorce, the marriage visa is F61, so half of you might have it. But after the divorce, there's two options, the periodical one, additional one, anyway. F63 is you get divorced due to Korean spouse class disappearance or at fault. That means death or disappearance is okay. You can get the visa, not divorce with the death or disappearance. So death, disappearance, or divorce due to Korean spouse fault, right? To get F63, you cannot choose. Remember, there was three options of divorce: settlement divorce, mediation divorce, litigation divorce, right? You cannot choose option 1 and 2. You should go to the option 3 and should get a verdict from the Korean judge, which literally says that this divorce occurred because of Korean spouse, and explain why. When you have that divorce decree, you can file for this divorce F63 visa. Without that, they will not issue this visa. So that is the first one, F63. And F62, you don't need that statement in the verdict, but you need to prove that you have a child and now after the divorce you got the custody. So you need to stay here in Korea to take care of the baby. Then you can file for this visa and you will get it after the divorce. Or you're non-custodian after the divorce. But at least you need to have visitation with the child with the proof that you have visitation right, and that visitation should be handled in Korea in person. So you have reason to stay here in Korea. Then you can file for that visa. But honestly speaking, the first one, like custodian visa, is quite, there's high possibility to get it. But as a non-custodian, only for the visitation, sometimes it's rejected. Because, which one is stronger, which one is weaker, right? That is F62. And F16 is temporary visa. It's mentioned 6 months. Let's say you got divorced. There's no child, but there's division of assets. So you need to handle it. Sometimes I handle that part. Most of my client who is not in Korea, divorce case, but it's litigation case. He's not in Korea. She's not in Korea. Asked me to proceed divorce case. Okay, we got a verdict in 2 years later, but there's asset to be divided. First, apartment should be divided like half and half. Pension, cash in the bank, things to be divided. I can handle it for them, but let's say you are in Korea and you don't have lawyer, then what can you do? You need to stay here in Korea after the divorce. Then you can file this visa, saying that I got a divorce decree. I know I don't have F61, but I need to handle after the divorce division of asset. So please allow me to stay here in Korea. That is F16. Or let's say there's none, just divorce, no division of asset. But you can also ask, let's say you stay here more than 10 years, even if there's nothing to divide it legally, but realistically, there's something you need to wrap up before you leave Korea. So you can file this case with that situation and ask, 6 months, I need to take care of, find my friend to take care of my cat, like that, right? So you can file this visa here. Yeah, it's like takeaways. So we've discussed understanding divorce types, consider all factors, jurisdiction, and visa after the divorce. Now, it's time for Q&A, and I'm happy to take your questions if you have any.
Thank you very much, Mr. Aaron Hwang, for your interesting presentation. Ahora vamos a pasar a la sesión de preguntas y respuestas. Tenemos 10 minutos. Las invitamos a que participen y aprovechen la experiencia del abogado para hacer sus consultas de manera directa. By the way, there was one question in the forms that we did. So I think we sent it to you by email. Maybe we can start with this question.
Yeah. But as I know, the question was like, if I have issue with my husband, I want to get divorced. Where should I go? Something like that.
I think it was more like, if I suffer domestic violence, where should I go if I want to divorce? So maybe it would be how to, you explain the regulations of divorce, but maybe where else could she go if she suffered domestic violence?
Okay, that's like happened a lot in Korea. So the answer should be with the divorce process-wise, you need to find a lawyer or file the case to the court. That will be answered. But if the litigation initiated or the settlement mediation process initiated, you need evidence of the domestic violence, right? He will deny. So there's several things how you can make evidence with the domestic violence. First one is call the police. You can afterward you can get the record from the police that will have the detail of your report, saying that okay, this woman reported police saying that what happened, and they could take your picture of your injury and time and date, so you will use that as an evidence in the court. Number two, you can take a picture by yourself with the injuries. If there's any kind of evidence you can get before the legal action, it will be very beneficial for you. So take a picture. And also there's many kind of institutions in Korea to protect women with the domestic violence. You can call them and get consultation. That can be used as an evidence in the divorce litigation also. Sometimes it's kind of not formal one. If you can text message to your friend saying that what happened now, that could be also evidence with the domestic violence. And all the process of the divorce. So as a lawyer, if you think about the divorce, from that moment, you need to record everything. There's automatic record setting in your cell phone. So record all the phone call and other than that, So domestic violence, you can think about police, hospital. Go to the hospital and get a kind of medical certificate with the injury. And take a picture by yourself and kind of women's defense shelter or institution.
Thank you very much. Entonces, si quieren apoyo con traducción, pero creo que quedó claro. Si quieres tú primero hacer la pregunta.
Thank you so much for your presentation. It was very interesting. I have two major questions. First, since in Mexico it prefers the no-fault divorce, as in the US, if there is any resolution from major authority of Mexico that recognizes the divorce, the no-fault divorce, is it possible that the Korea law system recognizes as well that resolution without having to make both?
Okay, so when you can get a verdict from another country, not Korea, could be Mexico or could be other countries, there's two different kind of options and possibility we need to go through. First one is, for example, divorce. You can use it in Korea with some kind of documentation. You don't need to get notarization, but you need to get apostille on that document in your country and submit it to the Korean Google office and community center. They will accept it. But if it is not divorce decision, if it's kind of contract verdict, then you need to go through the court system again to make it as a Korean court decision. It's not that long, few months, but at least Mexican verdict cannot be kind of validated in Korea without court legal action.
Okay.
But divorce is different.
I also have another question related to the custody. In Mexico, it also prefers the joint custody. In Korea, is that possible?
Very good question. Actually, when Korean people go together or go to the court and ask a joint custody, it's 99% rejected. Korean judges think there should be one custodian for the child, for one child, because that I understand their logic, because the custodian means parental right, means if there's emergency with the child, the person need to make a decision by themselves quickly. If there's a joint custody or joint parental right, it might be so hard to get both consent in emergency situation. So normally not, but there was 3 options, and there was mediation divorce, and both parties are foreigners. I have experience getting the joint custody decision many times, and I know that if they are foreigner and they have already kind of have the separation agreement, they want joint custody, and they also know that it is kind of common out of Korea, so they accept it. So yeah, recently there was kind of TV news that the Korean court changed their attitude about joint custody, but still it's not easy to get.
Thank you so much.
Voy a hacer un pequeño resumen para la gente que nos está viendo. Entonces, la primera pregunta era: ¿a dónde puedo acudir si sufro violencia doméstica y necesito divorciarme? Entonces, el abogado refirió las opciones de ir a la policía, tomar evidencias como fotos, grabar las llamadas, y además acudir a las entidades de apoyo a la mujer, como que hay instituciones aquí en Corea que ofrecen shelter y también asesoría legal. En la segunda pregunta fue sobre el tema de custodia conjunta. En este caso, en Corea, en el 99% de los casos, el juez rechaza la custodia conjunta porque debe haber una sola persona que tenga custodia para tomar decisiones importantes en emergencia. Entonces, esa opción, esa figura no está en Corea como está en México. Y la otra pregunta era, si te divorcias en México, ¿el veredicto tiene validez en Corea? El abogado menciona que si lo apostillas, tendría validez, pero hay ciertos casos que la decisión no pasa en la corte coreana, entonces tendrías que ir y hacer todo el proceso también en la corte coreana y podría tomar como 2 meses. ¿Había por ahí alguna otra pregunta? Sí. Adelante, por favor.
First of all, thank you so much for the information. And I was just wondering, not a friend, she was kind of forced to do like a mutual divorce because she found out that her husband was having like affair. So she tried to gather evidence, but I wonder, like in the case of adultery, what is the legal evidence that you can use in her case, because she didn't have something like physical, she had to do the mutual one. So I just wondering about that.
Yeah, that's kind of hardest part in divorce, litigation divorce. We need evidence always in the court. Evidence is the only thing you need. One thing I can tell you with the recording is a bit different in Korea. Many foreign client ask me that, is it legal to record conversation with my spouse without their consent? It is legal in Korea. If you are in a party of that conversation, you don't need to get consent of others. For example, we talk together and I recorded it without your consent, secretly. I can use it in any litigation. But he recorded our conversation without our consent. It is illegal. He will be punished. Criminal act. So, but if 3 of us talk together and I recorded it, it's okay because I'm the party, one of the party of this conversation. That is the standard of Korean criminal law, and also in the divorce case, you can use it. Actually, even if I recorded it without his consent, and the record, I can use it in the litigation. It is valid. Court will accept it as a strong evidence, but later on, I will be punished. So, most of our client is foreigner, so for them, for me, it is not possible option. So I always told my clients saying that you can use your phone conversation with your spouse. You can record your conversation with your husband secretly, but you cannot put your microphone or camera on his car and record it because you are not in that conversation. So that is the kind of line of the crime and non-crime of recording. But as again, I'm okay. If I can get divorced with him, I will go. Just leave Korea. Then you can get the kind of record and use it. That is about the recording. And also affair, adultery. People use private investigator to take a picture of the scene. It is kind of gray area in Korea, but everyone use it, and normally they will not be punished. But the issue is, it's quite expensive. And they don't work until they get a picture. We need to hire them for like 3 hours, like 1 day, like that. Imagine if you have your spouse, okay, tomorrow he will go and meet her and ask, tomorrow please follow my spouse. But the next day he went, then you just wasted the money. So, and it's quite big money. So realistically, it's quite hard to hire a private investigator. And you can see his cell phone without his consent. It happened a lot with couple, right? Because we know each other's password or pattern. But you cannot take a picture of it and use it in the litigation. It's also same. You can do that, but you will be punished.
What about, for example, if you send those messages to your phone,
Also, it's crime. Without his consent, you did it. It's kind of leaking information, personal information, without his consent. It's not possible.
So it's difficult.
You have question to me?
I work for foreign, but I think this is for people to like understand this better, like illegal filming, like in a better way, if they want to use this as evidence. So I have 2 questions actually. First, what if in a house, what if one of the spouse decides to use the surveillance device, like a camera, just put it in a house? Would it be considered as illegal filming?
No.
Okay.
It is okay. It is often used as an evidence in the divorce litigation.
Okay.
It is his fault. He knows there is a recording now. So.
And then another question is, sometimes in a household where there will be more than just like two parties, like the wife and husband, right? There will be like mother-in-law or a father-in-law or the other relatives, family members in the house. What if when the 2 couples fight, or one spouse abuses another, but the third party takes a video of that scene? Will that be considered illegal filming, or in the litigation, court, will that be considered a circumstantial evidence?
Filming, shooting a video is totally legal because it cannot be done if it is done unless it's recorded secretly. So you mentioned like they fight and
Yes.
mother-in-law, father-in-law shooting a video.
Yes.
Everyone knows that the person is shooting the video, so it's legal, totally okay. Can be used in.
Can be used that in that case that can be used as a strong evidence to the
Sure,
court.
sure.
Okay.
Video is most strong evidence still.
What
Yes.
about if they don't know? I mean, the couple, because some people have these pet cameras, and the other person doesn't know.
Shooting video without consent.
Uh-huh.
If you shoot a video without consent, it's more than just recording the voice, right? So it's illegal. You cannot use it. If you use it publicly or in the court, that will be punished. Yeah.
Yeah, so then the whole, let's call it like this, the whole point to make it legal is that at least both of the parties involved has to know about the existence of the camera or like the recording device, because I hear like some cases that it's not a friend, but like some cases that they used the recording of the surveillance cameras or like the security cameras in their cars, in the car that they share. They
You can
have
use it.
used those.
Yeah, you can use
And then the whole point is that they have to know about the existence of
No,
the
no, no, no.
device.
So the CCTV, you
Yeah.
mentioned that. There is also law about CCTV. All the CCTV, there should be notice that there is a CCTV, so that people know. So using CCTV in a divorce litigation, any kind of litigation in the court is legal, totally okay. So normally we can ask to the landlord of the building, I need to get that evidence because of that reason. So voluntarily you can get it. Or they deny it, then you can ask the judge to the court. Even before the litigation, there's strong reason to get the evidence first. Then you can ask the court order the landlord, so the court will obtain the evidence. Or if there's criminal issue with the guy or with the person, then you can call the police. And because of this reason, please obtain the CCTV. Should not tell them about divorce, but because of another reason, different reason, you need to get it first. So they have it, you can ask it later.
Thank you. Y bueno, para resumir, porque para las personas que nos están viendo online, las preguntas eran sobre cómo obtener evidencia si tu esposo te engaña, entonces que sea de manera evidencia legal. El abogado menciona que, por ejemplo, las cámaras en la casa, como ambos tienen consentimiento de que hay una cámara en la casa y saben, eso es evidencia legal en caso de litigio. O también puede ser legal grabar una conversación porque mientras estés participando en esa conversación. Entonces la conversación sea A y B, A o B pueden usar eso como evidencia, pero si C no participa en la conversación, C no puede usar eso como evidencia porque ahí sí sería ilegal o estaría incurriendo en un crimen de acuerdo con la ley de grabación. Y la otra opción que hay es contratar a un investigador privado, pero eso puede ser muy costoso para obtener fotos de la evidencia. Y las cámaras en la casa no se considera evidencia obtenida de manera ilegal porque ambos dan su consentimiento o ambos conocen que hay una cámara dentro de la casa. Tenemos una pregunta más en el Facebook, la voy a leer y ya con esto para cerrar la sesión y darle oportunidad al siguiente ponente. I will read the last question. It's on Facebook. Someone, because they are watching us Facebook Live.
Yeah.
So I will translate it for you, and it's in English actually. So it says, I want to get divorced and my husband refuses, especially because I want full custody of my 6 and 3-year-old. So 2 kids, 6-year-old and 3-year-old. I want full custody because I don't want to live in Korea after the divorce. What are my options? To add, my husband has numerous police reports for being aggressive and went to court once due to the report, but the judge dismissed, saying to just go to therapy. So what are the options for her to get full custody?
Yeah, last part, as I understood, it was like she reported it to the police officer, but it's just dismissed.
Yeah, there was police report, and then they went to court, but the judge just dismissed and say something like the solution is to get therapy.
Okay.
There was no other solution.
Okay, so quite typical case. Like, there is domestic violence and 2 children's custody issue. She didn't mention about division of asset, but could be. So this is full package of the divorce case. And beginning, he doesn't agree with it, so the only option is divorce by litigation. So we need evidence of his fault, so ground of the divorce. Actually, in Korean family law, divorce law, there's 6 different ground written in the law, but I didn't explain it to you because, again, the most important thing is domestic violence affair and abandonment. So she needs to get an evidence and with the ground why, even if he disagree with the divorce, how she can get the verdict, admission of the divorce from the court. First one, in that story, there's only one reason, right? The domestic violence. But if it found out not guilty, dismissed, then there could be not that serious to be found out guilty in the court. So we assume that there was domestic violence, but not that heavy to be punished by criminal law. But even if it is not punished in the criminal law, still can be used as an evidence in the court because the fact he assaulted her was true. So we cannot say how severe it was, but at least it can be a product of the divorce. But if he strongly insists that he doesn't want to get divorced, then she might have need more evidence to move forward. So I'll advise her to try to get more evidence with it. And last advice I can give her and you is that even I so far explained that if we consented, we need evidence, but there's an option, sixth ground in the law, and the sixth one, it says, even if there's no ground, even if there's no ground mentioned above, adultery, abandonment, violence, if the judge can find that this marriage cannot be maintained anymore, then divorce can be approved. So we need to try to get evidence as much as possible, try to explain what happened so far, even if it is not physically asserted or abandonment or adultery. Because of these many indirect reasons, we cannot maintain this marriage anymore. Then we can initiate it, we can get the verdict. We have that chance. And also there's possibility I experience is that when you or when your spouse initiate the divorce case, other party just say, no, I don't want it. But when case open and they need to go to the court, they hire the lawyer, they face the situation closely, they change their mind. Many kind of consent divorce was concluded with the kind of consented divorce. They just accept and try to get child custody, try to get more money. They change their stance. So before initiating the divorce process, after initiating the divorce process, people sometimes change. So even if you have strong ground or strong evidence, if you cannot suffer this situation anymore, it is worthy to initiate and see how the spouse changes.
Thank you very much. Y para traducir nada más, en esta opción cuando una de las partes no acepta el divorcio, entonces la única opción es divorcio por litigio y el abogado recomienda tener toda la evidencia posible de demostrar la culpabilidad del otro. Y bueno, thank you very much, Mr. Hwang, for this really interesting chat. Damos por terminada la sesión de Derecho Familiar para dar oportunidad al siguiente ponente. Vamos a tomar un break de 3 minutos en lo que conectamos la computadora por si gustan ir al baño o tomar agua o café.